Yeah.
So if you, Miss Wright, you wanted to call yourself as a witness.
Yeah.
So if you care to do so, uh, Miss Wright, as you're calling yourself, Holly Wright, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in giving testimony?
I do.
Obviously, questioning yourself looks kind of silly, and answering yourself looks even sillier. So what we do is we let you testify in what's called the narrative.
Okay.
Please tell me your story. Once you are done presenting all that you believe you need to present, then Mr. Chadwick will be able to cross-examine you. All
Okay.
right. So please proceed, Miss Wright.
And with that, can I refer to the proposed uh
Well, which exhibit?
um
You have sent three to the court.
I
So
sent three. So
correct.
and
Which one
I
have you?
and I don't need to do, I mean, I can kind of go in order but I just didn't know if I can refer to those ones yet or
You
no.
cannot refer to them, but you can bring them into a proposed exhibit, and then you may proceed to see if they will be accepted by the court.
Okay.
So which exhibit are you um, at this point?
Um it's the I don't know which one it's gonna, if it's exhibit one, I guess.
And which one is it? Because I've got
It's
three, but they're not labeled.
okay, so that would be the attendance log.
All right.
This one.
This is the updated version of
The
what Mr.
updated.
Chadwick presented as exhibit number one,
Okay.
correct?
Yes.
All right. Mr. Chadwick, if you had the opportunity to review that,
We have.
any objection to that at this point?
Yeah, we object.
On what basis?
The exhibits were due months ago
I
and
understand.
were not provided to us. There's also there's no foundation for this. It appears to be something that someone could have prepared off the internet, but could have been prepared by someone other than someone from the school district. We had the school district attendance administrator here. He could have authenticated this. He's not available. He's not been called as a witness by Ms. Wright. So we're kind of looking at a document that no one here can authenticate. We object to its admission.
All right. At this point in time, I'm going to hold your objection in abeyance at this time. I'm going to let her testify to it to find out if there's anything that may be ascertained from it. Then we'll discuss its admissibility at the end of her foundational testimony. Ma'am, you may testify to this document and we'll see if it's admissible or not.
Okay. Um, with school just starting up, I was able to go to both Jefferson Elementary and the middle school to this morning actually, because it's the first time I'm able to get in there. And they were able to print it out, just showing the updated version, since I think the one that was already submitted as exhibit one stopped in, like, the latest date was in February of this past school year. And school didn't end until June. And the majority of her absences or tardies are actually after that time that the first one has shown.
So they were after the March that ended?
So the one that was exhibit one,
Ended on February 28th of 2024.
yes, and that, there's since February 28th, there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 more items that show on the updated one that I'm proposing we enter.
And those show supposedly what?
It shows
Child was not at school
correct.
under your watch.
Um, actually under between both of us, it just shows that it's just printed from the school. So regardless if it was on Tyler's or mine,
That's what matters. Whatever you received, that was one of the things about the initial one was the fact that it showed which ones were yours and which ones were Tyler's.
And I don't know that that was accurate. The one that I'm proposing right now shows which ones are technically Tyler's and which ones are mine, but it also shows the ones that she was excused due to illness, and then the ones
and this is all from March to
no,
June.
this list that I'm proposing that we enter is the whole entire school year of last year.
Okay. And it is the updated list?
Yes.
Where did you receive it from?
I got it straight from Mrs. Teaker at the school.
Mr. Chadwick, update your objection, please. Because again, the court's supposed to get updated information. We started this hearing and this did end in February of 2028. When we started these hearings, it was later in the school year. Should not the court receive updated information?
Well, there's still a lack of foundation. Ms. Teaker is not here to authenticate the document. It was received.
Well, it would have gotten it. Although you did bring in the worker to authenticate it, it was pretty much semi-self-authenticating. It's not prepared in anticipation of litigation. It's not prepared by either party. It's prepared by the school in its normal course of events, correct?
Yeah, I can see that the document, according to itself, was accessed 9:29 a.m. this morning.
Right, which would be the update for last year, correct?
Yes,
Correct.
we've had things on July 3 and I believe July 18, another hearing in August already.
Right. And again, we had hearings in the summer and you only presented evidence up to February 28th.
And
As
this,
soon as you got it. So I think the court, I don't believe,
Excuse me, we're required to present our exhibits at least 2 weeks before this hearing. We complied with that. The exhibits that we had were up to date
Right.
at the time. This is
at the time, and then they needed to be updated by court rule. They should have been updated and authenticated.
I believe that. No, I don't think so. I think that's
Okay.
the court rule.
Well, at this point, I'm going to say that I need to see the updated and what's been going on. I'm not going to just cut it off when we started a hearing in the summer. And the last thing that I have is dated until the end of February of 2024. I will take it into account, but I'm going to say this was not prepared in anticipation. It's identical to your document. So I will allow cross-examination on the fact that if there's any discrepancies, but this looks like it was a document prepared and presented by the school. So I'd like the updated information to find out what was going on. And I will take also into account that during that time period, she was under notice that, because I believe the motion in this case was filed when, Mr. Chadwick?
2023.
Referee, you muted yourself.
I hate this fob. My elbow hit it. Again, she was on notice, and I will take that into account as well, that she knew to better do what she needed to do. So, but I think I'm going to allow this as exhibit number. I believe it's, where did my exhibit list go? It's number 11.
Yes.
and today was really the first day that the offices were.
And that's the other reason, because I think Mr. Chadwick might have updated this himself had he had the opportunity, but I realize schools just opened and during the summer you don't have any access.
Yeah.
So I will accept this exhibit number 11 with the qualifications that I'm going to note that this is an updated version of what you presented to the court, Mr. Chadwick, and I will note that it's prepared by the school. So I will find that that's appropriate to enter at this time, with weighing it appropriately as well, considering I don't have the school person here to authenticate it and to review it. But if I remember correctly, since I will rewatch this, I'm not sure he was much help, in all honesty. Vaguely, I recall the testimony was he kind of reviewed it and he didn't have answers to some of the questions that you had, nor some of the questions that I had. So noting that, I'm going to allow this to be entered as exhibit number 11.
Okay.
Please proceed, and you need to testify on this exhibit, ma'am.
Okay. So this exhibit shows the whole absence and tardies for 5th grade. So this past year from 2023 to 2024. And I know attendance is a huge issue in this case. The colors on there, as you can see, the ones that are colored orange are actually ones that she was ill and has doctor's notes for. Either that or she was at an orthodontist appointment. So all of those ones are excused, as you can as it shows on there.
And when are those?
There's several of them. So 9/19 of 2023, 11/6 of 2023, 11/7, 8 and 9, 11/16, 11/27, 11/28, 12/19, and that was all 2023. But during the 5th grade school year, so last year, and then 2/22 of 2024, and then June 4th and June 5th of 2024.
And I will note, Mr. Chadwick, that your version indicated that 9/6 and 9/5 the child was sick.
Excused or at a doctor's appointment, that would have made her either late for school or not at school for those times.
Okay. Well, those will go next as backup to this. So I guess they testify again as to what dates you believe the doctors were involved.
That would have been September 19 of 2023, November 6 of 2023 to November 9 of 2023, November 16th, 2023, November 27 and 28.
Well, the 16th, I believe even your exhibit, Mr. Chapman, says that Tyler had the child for an ortho appointment on that date.
I-
And November
I
27th was
have
also
to-
Tyler with the doctor's
Yeah.
appointment as well.
I have to ask for a recess. We don't have the exhibit, and I have thought it was in here, and I can't find it in my online things.
So you lost it too.
I did, yeah.
Do you want me to email it to you too?
Very good at email now. We figured that part out. So if it
Yeah.
can be emailed to Talia, I'll have it. I'll print it, and then
No problem. I think Miss LeVay, did you receive it? Because I know I got it.
What exhibit was it?
It was exhibit number 1. It was the one that had the purple and the purple/magenta.
Okay,
And
I'll
yellow.
search for it. I know. I
If you don't have it,
somewhere.
I have it because, like I said, I got yelled at by my wife for printing it off on the color printer. But yeah, I'm glad I'm not the only one that missed it. So this is one of those exhibits that's problematic because we seem to be losing it.
right.
Well, you sent it to me, Mr. Chadwick, so I know
Have it.
Talia
And I
has it.
actually,
Yeah.
when I was, highlighting the ones that were doctor's appointments, I actually referred back to that one where, to confirm that. Yep,
Yeah,
it was the
because
ortho
Tyler
appointment.
Tyler has 4 of them that were listed in exhibit 1 that he had the child out. Well, one was a weather excuse due to weather.
Yeah, this will save time because we'll be able to look. I suspect
I
most
just-
of these are going to match up.
Yeah, that's what my thought
think-
is. Well, some of them were not listed; they were just listed as absences by you, Mr. Chadwick. But if she can back them up with doctor's notes and saying, "Hey, look, this is medical,"
Yeah.
that she's allowed to, because again, that's what we've told her since day 1. She can testify as to what these mean.
All right, very good. Let's
So we'll recess a moment. We'll get that back to you. And hold on, Miss LeVay. Oh, you already sent it to Talia. Exhibit number 11 as the updated version of exhibit 1. Miss Wright, you are still under oath. Please proceed.
Okay. I think I just listed off the days that she wasn't at school or was tardy because of doctor's appointments or being sick. And if you have the exhibit in front of you, the ones that are green highlighted are actually the days that Tyler would have got her to school. Or it was his response, like it was his school day to have her. And after counting those up, it looks like 9 of the ones from last year are on Tyler's time. 8 total absences, like full day absences, and 1 tardy. When you look at the ones that are in blue, those are the ones that were excused tardies while Vanna was with me. There's none that are full day absences at all. Just the 6 tardies. On the exhibit, the ones in white that are not highlighted, you'll see it says TU next to it for the code. The school clarified that it was tardy, unexcused. On those days, those are days that Savannah walked to school. And if you look at the dates on there, that was during the winter. So she was walking in the snow. There were several days, either right before or right after having no school for a snow day. So it was clearly, weather related. And the T is representing tardy opposed to being, an hour late. Tardy more like less than 5 minutes late. And I think it's come up already that she struggles with getting up and down the stairs, pretty quick.
Are you saying those days are on your time though?
They're on my time due to her walking during the winter. I think the ones that are unexcused are all in November are in between November and February. And these are ones that are tardy unexcused. So that means no one checked her in the office to say she's tardy. Here's the reason why. These are days that she was walking to school, showed up less than 5 minutes late, and that's why they're unexcused, because these are ones that I didn't even I didn't even know she was tardy at that time, because it's still under the threshold of where they call home and say she's not at school or she's late or she's absent. These are ones that she's walking in as the bell's ringing. Instances like that. So again, if we count them up, if we count them up, disregarding the ones where she was ill and either ill or at an orthodontist appointment, she went to the sleep lab one time. Those are the ones in orange. If we don't look at those ones and just the other ones, besides her walking to school and having those tardies during the winter months, there's 8 full absent days on Tyler's time and 1 tardy. And on my time, there's 6 tardies that were excused that whether we overslept or something. I can't tell you the exact reasoning for the 6 tardies, but that's a huge difference than the numbers that were presented by Tyler as far as absences and tardies go. And I know when we spoke with, I think it was the first witness, someone from the school, he wasn't really sure what the codes meant. The only one I'm unsure of is the one from 9/5 of 2023, where it says UPN. That one I'm not sure what that's supposed to represent, but the rest of them, it's pretty clear. She's, I'll take responsibility for the 6 tardies and her walking. I wake her up with plenty of time to get there, but with the weather, and I think I even wrote down the days. I mean, within that mix of days, school was canceled due to snow. Several, days before that, days after that. So it was definitely snowy, icy out. So, and the unexcused ones, and I think Tyler, you can say the same thing. I know it's my turn to testify, but being unexcused, we don't even know about that. Whereas the excused ones are ones that we would walk her into school, sign saying, "Yep, we know we're here. She's late." The unexcused, obviously, neither parent knew she was tardy. And I think I guess I don't have much more to say about what it shows on there because we can all see that. I know the other exhibit that I was proposing is her final report card from last year.
Trying to bring that up. Mr. Chadwick, do you have it?
I think so. Yes, we do.
Okay. Obviously, I'm sure Mr. Coleman got that as well.
Yes, I did.
So, any objections to her final report card?
Don't have a date on it. I see it's the 2023 report card. And I'm seeing.
Okay, so that wouldn't be last year's, that would be this year's.
It's 2023 to
I'm sorry.
2024. So this was last year, her 5th grade year.
Let's make sure we're all looking at the same document.
And it looks like there's one exhibit that has the Ionia Public Schools logo at the top near the center.
Okay.
This would be one that I'm proposing we
Okay, I think I've got that one. That's, I think, her exhibit.
My exhibits come in chopped up pages, so
so do mine.
It appears to be, you can't focus on this. It appears to be a 3-page document.
That's what I'm trying to pull up and look at. So, but it looks like I'm looking at what looks like to be a report card. I can't see the age, probably until I print it. But if this is the actual report card, any objections for 2023-2024?
No objection.
And that's the proposed exhibit you're asking for, Ms. Right, correct?
Yes. Yep.
Okay.
If we could just put them together as one exhibit. I mean,
I'm going to put this as exhibit number 12. That way I can, because right now I'm just trying to read it.
Yeah, the second.
Even I can't even excuse old eyes for this one. This one's just small.
I'm sorry, and I can.
No, when I print it, when I actually download it and print it, it will be different.
Okay.
But as long as Mr. Chadwick and Mr. Coleman have it.
Yeah, the second exhibit appears to be a single page. Also, the bottom 8 has been chopped off, and at the top of it, it says social studies in the top left.
Okay, so that one I am not able to pull up at this point in time. So.
Oh, okay.
Oh wait, yeah, I think I've got it. Yeah, I just found it.
It's all report card, sir.
It's all one report card. So
yeah.
This is a report card for last year. The one that we're talking about is last year's 2023
school year.
Yep.
Okay.
And it's just 2 pages. It was just 2 pages.
We'll enter that as exhibit number 12.
Okay.
What do you want to testify as to this one?
It just in the top left corner, it does show the excuse, like her excuse, unexcused, tardies, the actual numbers on there that will match up with the exhibit exhibit 11. And that is a far different number than what was previously stated on their end, as far as number of absences and tardies for this past school year.
Okay.
And
I guess that's a backup to exhibit 11 and exhibit number 1, Mr. Chadwick, so you may cross-examine on it, obviously.
in addition to that, I know it was brought up that I don't remember the exact words, but her attendance and her being tardy, the impact on her academically. On the second page of exhibit 12, there's the comments from the teachers that she's made, sorry, I can't read it so small. She's made tremendous growth throughout the year, and that she's progressing. So, and that she was, did well enough to move on to 6th grade.
Which she is currently in, correct?
Correct. Yep.
Okay. All right. Further testimony, ma'am.
I don't have any other testimony on it. I just wanted to make sure we had that.
Okay.
Those 2 items to account for her absences and just to show that she was making progress the whole year. The times that she was either tardy or absent, whether it was sickness or for whatever other reason, didn't have a dramatic impact on her academically.
Right. All right, Mr. Chadwick, you may cross-examine this witness.
Am I able to say any? I mean,
Oh, well, okay, you're not done yet? No,
I was done with just those exhibits. I just didn't know if.
No, okay, no, please continue. I thought you were done.
Sorry, I just want to clarify a couple things. Since at the time I couldn't, I couldn't give my testimony on it. I know Tyler had brought up Kristen Preston, Matt's cousin, and brought up her a few different times. The reason that I even came to know her was because I was taking guardianship over her daughter, her 6-year-old daughter. We had a court date. The daughter ended up going with her maternal grandma. But that was the extent of our interaction is, she was willingly signing over her daughter because she did know that she needed help and needed to get out of a bad situation that she was in. So, we went down and she paid the $186 for the court fees, and her daughter stayed and was in my care. And that's where Karma, the dog, that's where she came in. That was Harmony's dog. The little girl I was taking guardianship of, it was her dog. So, I just wanted to clarify that. As far as this custody in general goes, in my mind, there's no, Vanna's missing out either way. She's emotionally, mentally, even knowing that we have court coming up or knowing that this is going on, that's affecting her in a big way. And she'll even say to both of us, and I've heard her say, why are we doing this? Why can't we just keep it like this? I want it to be like it is, 50-50, where, and that's pretty much what it has been. Her whole 11 years she's been living is parenting time.
I object to the say from the child.
And I'll grant that objection. You can't say what the child is saying, ma'am. I'm sorry. It's hearsay. I have met with the child.
Okay.
I will take into account her reasonable preference.
Okay. And I guess so for the past, she just turned 11. In that whole time, we have parenting time has been almost at I think it's 40-60. I think if we look at it exact. So what Tyler's proposing would be a huge change in Vanna's life. And I don't know that for any child, that's in any child's best interest. I guess if it was some sort of bad situation, whatever, but she's safe at both homes. She's loved at both homes. And to try to change it to her only being with me a couple days a month, it hurts me because I know that that would hurt Savannah. Especially after 11 years of it being one way, to have a drastic change like that even proposed seems so far out there. And I think, I know Tyler spoke about this before, that my fiance and him were friends. And ever since we have been together, me and my fiance, it does feel like the decisions that are made when it comes to Savannah are done in a way to hurt me, not to do things that are in Vanna's best interest. But only to hurt me or to put himself first. And I apologize, I'm crying. I know our daughter loves both of us, and I've never, in this 11 years that she's been born, I've never taken time away from Tyler. I've never tried to keep her away from him for anything other than unless it was ordered by the court or by CPS. But I've always encouraged their relationship, and even the relationship between her and her grandma over there. And I just hate seeing I don't know what logically this proposed switch does not make sense. It's not going to be in Vanna's best interest whatsoever. I know right now we have joint legal, and I have had sole physical custody since since the order was established. And I feel like I've been able to keep encouraging that relationship with Tyler and Vanna. I've been able to get her to school. I've been able to get her what she needs. Even with my eyes, and even with my medical, having diabetes, and I've still been able to provide a home and provide food and clothes and all the necessities that she needs to live. I know there hasn't really been a change in circumstance enough to even consider changing custody. I know that that's the law in Michigan, and I just don't see it. I know. Even after the situation, there was a situation in 2022, even after the court, I don't know what word to use, even after the ex parte order that Tyler had, extending his parenting time for 2 weeks while I was in the hospital. Once that ended early because I was out of the hospital, he chose not to resume the normal parenting time like the court order had said. That went on for over a month of Vanna not being able to see me or talk to me. And I think when I counted it up, and I could be wrong about the days, but it was close to 45 days that he kept her from me, even after CPS and even after the judge said to resume parenting time. So I did civil standbys when it would have been our scheduled day just to hand off. Every time it was a scheduled day that I would go and pick her up, I'd bring an officer with me and he would say no. And at that point there was not much we could do because it was a civil issue. It took me going and getting an ex parte order, which I didn't even know. I didn't know I could even do this. I'm getting an ex parte order to have him return her and to resume the parenting time. That event in that summer took a huge toll on Vanna. And you can see that in the exhibit 1. That school year following that, she was absent a lot and she was tardy a lot. But emotionally, mentally, she had gone through something that no kid should ever have to go through. And I know it keeps coming up, the instance when I had let her stay with Tyler an extra day because, I don't think they were going to a movie or they were going to dinner or something. And I came to pick her up. And I was upset. And that is because I had already let her stay for an extra day. And what's in my mind, anytime that she wants to stay, I have to juggle with what's going to happen. Is he going to return her or is he going to keep her for this extended time? So me being upset that one specific day, I think is very justified in that.
Ma'am, calm down. It doesn't help the testimony. I understand this is emotional. Take a deep breath. And let's finish your testimony. Continue.
I just think that when it comes to thinking about what's in Vanna's best interest and what she can grow from and encouraging her as she's growing up and becoming a young lady, I think keeping the current parenting time and the current custody, as far as joint custody, joint legal, and me having full physical, I think is, there would be the way to go. As there's not really anything that has gone negative in the 11 years that it has been that way. Yeah, I don't think I have anything else that I need to say.
Okay. Mr. Chadwick, if you care to cross-examine this witness.
Thank you. So let's talk about the house you have provided for your daughter.
Okay.
You purchased it for $165,000 in 2021. Is that correct?
That's correct.
You took out a mortgage that same month for $162,000.
I believe so.
2 years later, in 2023, December of 2023, you had to borrow another $19,000.
I guess I'm not understanding when you say borrow, because I paid in. I thought we already discussed this previously. I paid extra, insurance on it in case something happened, as far as like it did with me losing that job that I had. It's not a loan. It's a forgiveness. It's a program that works in situations like mine.
The question was whether you borrowed another $19,000.
No, I didn't borrow another 19,000 at all.
Mr. Chadwick, you have information that I do not. It's my understanding that she bought the insurance through HUD. And in doing so, if something happened like this disability that I believe was anticipated when all this was done, that HUD would give her the extra money. But the loan is not a loan that's to be repaid. It's a loan to keep her in her home. And that's the insurance that she bought. She never received the money. It just kept her home in her possession, correct? Or am I missing something?
I'm looking at a document that was signed by Ms. Wright in December of 2023, 2 years after she got in her home.
Okay.
The amount, I'm highlighting it with my cursor, is $19,323.78. The
Correct.
document itself is recorded in the Ionia County Register of Deeds, and
Correct.
the document is called a partial claim mortgage.
Correct.
Right.
In other words, the money went to pay for the mortgage. She never received money. That's my understanding from former testimony.
But she has to pay back the $19,000. She's referred to in this document as the borrower.
No,
Yeah, she's the borrower, but it's my understanding that it's not to be paid back because it's federal grants that are there to maintain the household. And I know we've gone back and forth over this. Is there something you have that says that she actually received $19,000? And if she has to pay it back, even if she does, it's not income as to the $19,000, it's a loan. And if she doesn't, she's exonerated because it's a federal grant program. And I can't hold that against her by federal law.
I don't
So
think
am I missing something?
if I saw the word grant in this, I'm showing you the document, Mr.
No,
Edwards.
I understand that, but I
would
mean,
tell you it says grant, but it says borrower, and it says
yes, it does.
$19,000. And at the top of it, it says mortgage. And it was recorded by the Ionia County Register of Deeds. What do you expect us to do with this document? I simply want to know if she borrowed $19,000 or not. Her testimony is no, she hasn't. You
that's
can assume
correct. I
whatever you
have
want,
not.
but I'm looking at a document with this witness. I want her to testify under oath whether she borrowed $19,000 2 years after she got in the house and got the mortgage. Question is, did you borrow $19,000? Yes or no?
I guess I don't know how to answer this because I didn't borrow 19,000.
All right, let me cut to the chase. Man, did you ever receive $19,000?
No.
Okay.
Okay.
Chadwick, proceed on that.
All right. Did you make any payments between 2021 and 2023 on your house?
I'd have to look at the dates because they had COVID. Because of COVID, they stopped payments for 6 months on my mortgage. So I'd have to look at the dates exactly, but I'm sure I did.
Were you working at the time?
Between what dates?
2021 October through December of 2023.
Yeah, I was working for some of it.
And your testimony earlier was that you stopped working in January of 2023.
So I guess to clarify, I worked at one business, which is now Corewell Health. And then because I no longer could do that job, I worked from home with cardio diagnostics.
And then in 2023, you did the same transaction, a partial claim mortgage, this time for $4,093.43.
Yes, it's called a partial claim. No, I didn't receive cash or a check or anything that came directly to me.
You needed to do this because you were behind on your mortgage. since December of 2022?
Is that a question or are you,
Yes.
Yes.
okay. I needed to do that because I'm waiting on disability. And this is why I paid for this insurance so that I had something like this in the event that I needed it.
Do you recall making any payments between December of 2023 and April of 2024?
Yes.
Okay, why did you need $4,000 in a partial mortgage? If you made, did you make all of your payments or did you miss any payments?
To be honest, I would have to look at exact dates and see what days I made the payments on, but, as I've explained before, that's what this is there for. That's why I paid in for this, so that in the event that I needed, I was waiting on disability or something, that
And
this would be there.
what exactly did you pay in?
I'd have to look at my mortgage paperwork and see what it is exactly called or how much I paid in for it.
Did you make a check out to some government agency or bank, lender?
It was part of my loan when I signed all my paperwork. I mean, it was all wrapped up in my down payment and in my closing costs and all of that.
My question was, did you make any payments between December of 2023 and April of 2024 that you recall?
Yes. And my answer was yes.
And how much did you pay? And when?
And what I answered to that the first time was that I would have to look and find out exactly what day it was and how much I paid.
And ma'am, you answered that like 4 hearings ago and you still don't know?
I mean, I can pull it up. I mean,
Yeah, you should have pulled it up before we even, come on.
What is your,
I didn't know he was gonna go back on this again because
Well, it's still an open question. You were asked the question, you said, I've got to look back. Have you paid and what have you paid?
well, my
Been an ongoing issue over
mortgage is-
3 of these hearings.
my mortgage is 1388. So you give me a second, I can pull up my app.
And forgive me, Mr. Chadwick, for interfering, but I'm like, I'd like the answer too. What's been paid and when was it paid?
So in March, I paid 1392 because I had a late fee. That was the one I was able to make in March. And then where are you going up until now? What was your ending date? Because I already paid.
when was your last house payment made?
Last month,
How much did you pay?
or I paid 1388. Is my
You paid 1388 in July of 2024.
at the end of July. Yep.
What is your monthly payment amount?
1380.
Have you made any other payments this year, 2024, on your house payment?
I didn't have to because I had this partial claim.
No. Your answer is no other payments in 2024?
My answer is no, I didn't have to because that's the partial claim covered my payments. So I'm up to date on my mortgage. That's what that partial claim does. It gets it so that you are in good standings and you're up to date on your mortgage.
Mr. Matthew Preston lives with you full time?
Yep.
Isn't
Yes.
Isn't it true that he is working?
Sorry, I don't know if my thing needs to be turned up or
Is he working?
he works a couple days a week.
Is he contributing anything to your mortgage?
He just started this job, so he hasn't even got his first paycheck yet, but he will once he gets that first paycheck.
You're working now?
I just started, I can only work so many hours because of disability, and they've had to make accommodations so that I can see what I'm doing. I'm still training right now, to
the
make
an-
sure that it'll work out.
Ms. Wright, you don't have to tell me everything you know. Just answer my question. You are working now. The answer is yes.
I'm training for a job, yes.
All right. Have you received any paychecks in that new job?
I received one paycheck and it was for 3 days of orientation training.
Okay. Your job is at Green Acres in Ionia,
Yep,
and it's a convalescent home retirement facility. Very nice.
it's a retirement community.
Okay. What will you be working there? What are your hours going to be?
I don't know yet. I have to get through the training first and make sure that I'm capable of getting through it all and doing the job before I even get a set schedule. Right now, training is different hours. Sometimes it's 6 in the morning to 2. A couple days ago, I went in for just an hour in the middle of the day.
Uh, what are the requirements? What are the maximum number of hours you can work without losing your Social Security benefits?
It's less than, and I might be, again, I can't see the greatest. So the paperwork that I have, I've given to my job. So I believe it's less than 24 hours.
Per week?
I think it's, yeah, per week.
All right. This is a copy of our exhibit 13. I don't know if I don't believe it's been admitted.
I don't recognize it, so.
So I'm going to start at the bottom. The last entry is May of 2024. And
I'm sorry, I can't even see what
okay,
we're looking at.
I'll tell you what it says.
Oh.
May 9, 2022, it indicates there was a past due bill and a shut off. They charged you $75 to turn the water back on. May of 2022. Do you recall that?
I don't recall the exact date, but I thought we already went over this, but I see that it's there.
All right. It is $75 when your water's shut off to get the water turned back on.
And I'd like to thank the attorney for making me look weird while I'm trying to get close to the screen to read.
I know I can't get, I can't see it.
I can actually read it, but I have to get really close. All right, no problem.
Oh,
There you
it's just,
yeah.
is it just it's just the
Yeah,
right off on-
it's a water shut off, past due shut off. Yeah.
Yep.
All right. So you recall that happening in May of 2022?
Yes.
You recall that happening in November of 2022?
I guess, yeah. I mean, typically if in those instances, if it gets shut off, we're able to get it back on that day or.
Okay.
So would be such a small amount of time that I can't pinpoint the date, but
You remember it?
I don't remember that one, no.
Okay. You recall that happening in February of 2023?
No, again, I'm not sure if you're familiar with how the city, they come out and if they stop at the house and have to shut it off, and then you.
Is right.
Hello?
I think you froze.
She freeze? Not only did she,
You're back.
no, she's still there.
Okay.
Okay.
So February 2023, you do not remember?
I don't recall that one. Again, I'm sorry, I don't recall the exact dates. It's such a
May of
quick
2023?
on and off. I'm sorry,
May of 2023?
May. I don't, sure, yep.
And August of 2023, it was a past due amount and your water was shut off, cost $75 to turn it back on.
I don't recall that one either. And again, like I said, if they,
Ms.
the $75 fee is if they
and
have
all
to
the
schedule the
qualifiers,
people to
I
come
just,
out.
and you say,
So whether they shut it all the way off or
Okay,
not.
okay, Miss Wall, ma'am, if you just answer yes or no when it's a yes or no question, okay? Thank you.
Okay.
you recall your water being shut off in November of 2023, last November.
No,
You recall your water being shut off this year in February of 2024.
February of this year?
Yes.
No.
All right. Isn't it, do you pay the water bill?
I'm sorry, I can barely hear you.
Do you pay the water bill?
Yeah, so I would pay the water bill, yes.
All right. Isn't it due every 3 months?
It is due every 3 months.
So isn't there a pattern here of having your water shut off every 3 months because the bill's not being paid?
So when the bill comes up and then if they are going to come shut it off and then I pay it, then they turn it right back on, or they don't even turn it off and then just charge me the 75 for sending the guys out anticipating to have to shut it off.
Okay. So you can see that there's a pattern of just about every time there's a 3-month water bill due, your water gets shut off, or they charge you $75. You see that pattern?
I can see that pattern. Well, actually, I can't see that pattern because of my disability that, affects my eyes. And that's why I'm, in the situation that I was in. But
All right. Does Mr. Preston help with the water bill?
I mean, he will once he's just started working, like I said, when he gets paid, then
When did you get your first paycheck from Green Acres?
so it would have been today's Friday, so it would have been last Friday.
So when you had your water bill or water shut off or threatened to be shut off, who paid the water bill and the $75 to get it back on?
When?
Each time it was shut off, who made the payment?
So I either I made a payment or my family helped me with a payment.
Did your mom help you with the payment or your dad?
I'm sure they had. I mean, I have a lot of family, so they know the situation that I'm in and they try to help as much as they can whenever they can.
Your mom testified that she gave you some money last week and it was $20 and that
When her and I went out to lunch, yes. She bought lunch for us.
she would never give you more than $20, $25. That was her testimony. Do you recall her saying that?
Yeah.
But your testimony today is she helped you pay off the water bill, including the $75.
No, that's not what I said. I said my family.
Okay, who helps you and your family to pay these bills?
I don't, oh God. I mean, I have aunts and uncles that help me. I have my grandma that helps me. I have two sisters that sometimes help. I mean,
You suppose
anyone that can. My son will, when he needed to, or when I needed it, would give me $10 for gas here and there.
Okay, I asked an open-ended question. I'll try not to do that. Do you suppose your family could help you before the water gets shut off to avoid the $75 fee?
I mean, I guess if somebody had the funds to do it and if I was asking for the help, but like I said, in most situations, they come out, 90% of it doesn't get shut off because I'm able to pay it right then.
Well, we documented two $75 fees in 2022, at least 3 in 2023, and at least 1 this year. So it does happen quite often. Would you agree that it does happen quite often?
I mean, the bill comes every 3 months, so I mean, I guess that's quite often.
You are not allowed to drive a car right now?
I am allowed. I have a valid driver's license.
Matthew,
I choose not to drive for my own safety and for the safety of other people if I'm having a bad eye day.
Matthew Preston is not allowed to drive?
I have no idea. I mean, he's got a valid driver's license right now, so
The answer is yes, he is allowed to drive.
I don't know. I don't want to look over and yeah.
No,
Yep.
no. Okay. Can't have assisted testimony.
Okay, yeah, because
To the
I don't,
best of
to
your
be honest,
knowledge.
I don't know. To my knowledge, yes, he's got a valid license.
All right. How long has that been the case?
I don't know. I know, he did some time for driving on a suspended and then got out. So I don't know. I don't know dates or
Has he been driving you around recently?
um I guess. I mean I recently sometimes, yeah.
And he also drives Savannah.
Um at times he has driven Savannah.
All right. Has he driven Savannah before he had a valid driver's license
I don't think so.
within the last 12 months?
No, I don't believe so.
I'll try and move around a bit.
I was going to say, I don't think he's frozen. I think he was reading.
Mm.
All right. Believe it or not, I never knew how to use the share screen button until this case.
Well, welcome to new knowledge.
Right. All right. This one has been admitted. This is exhibit.
I thought we
Oh.
got rid of that one because we couldn't see who was in
Well, no, this one is the same exhibit, but if you're looking at it from this angle, now all of a sudden I can see faces.
This is court exhibit 10. This was admitted.
Correct.
Okay.
Last hearing. Now, I'm going to use my cursor here.
The printed copy I have is not legible, but this one is.
Okay. You see a smiling face here? That's Matthew Preston.
To be honest, I can't tell who that is, and I can't tell what car that is either.
Okay. You see that he's on the driver's side. This person, this unidentified male, is on the driver's side.
I guess I to be honest, I can't. Again, I can't.
Yes or no?
Your question is someone on the driver's side? My answer is going to be no because I can't make it out. I'm sorry.
This picture was not taken in Britain, correct? So I would say that that's the driver's side. I see a steering wheel in front of the party now, and I see a smiling face that can be identified.
Okay.
All right. The hand obscures this face here, but that's your face. Is that correct? On the passenger.
Again, if it's my face, I
Yes, no, or I don't know.
I don't know.
Right.
I can't see.
Ms. Wright, the passenger is wearing a Thor t-shirt. The mighty Thor from Marvel, correct?
Again, I'm sorry. I can't. I am working on my
Oh yeah, that's Thor.
printout. If it's printed out, I could see, but I
That's all right. I might
literally to me, I can see the white rectangle and then
it's a lot of
a
words.
gray,
Yeah,
just a gray
I
bar.
don't know.
Yeah,
Okay. You're the one under oath. You'd say, I don't know. We believe you.
Okay.
There are very few judicial officials that can honestly say that I collect comic books and that's Thor.
Okay.
So I can take judicial notice at this point.
Thank you. Thank you. Now, yes or no, do you own a Thor t-shirt? Isn't it true that you own a Thor t-shirt?
No, that's the mighty
Yes.
Thor. There's a difference.
Okay. A mighty Thor t-shirt from
I
Marvel.
haven't had a Thor t-shirt in 2 years.
Okay. Do you recall Tyler Coleman taking your picture that you see represented here?
I don't recall him taking this specific picture just because I honestly can't make out the picture, but I recall him taking my picture several times.
Yes or no? Didn't he take this picture at Jefferson Elementary during the past school year, 23-24?
I don't know.
Okay.
Because if it's a white car, I can't even tell if it's, see if I can scroll down.
All right. You have type 1 diabetes.
Yes. Yep.
When your body produces no insulin. So you're
Correct.
insulin dependent.
Correct.
It's not a situation where diet or exercise can cure the problem. You need
Correct.
insulin to live. Correct.
Correct.
When you go low, you get you go unconscious. Is that right?
No, I've never gone unconscious from being low blood sugar.
All right. You can tell your body gives you signals when you're going low on your blood sugar.
Yep.
And your mother testified that you also have a CGM, continuous glucose monitor.
Yep.
That's hooked to your phone, is that correct?
No, it's hooked to my insulin pump.
So when your blood sugar goes low, the insulin pump will alert you that you're going low.
It'll alert me if I'm going low or if I'm trending up or trending down. Yeah,
All right, let's go to the other end. When you have high blood sugar, you develop in your bloodstream ketones.
correct.
Those are a concern because ketones indicate that your body is being starved.
Not necessarily, but I mean, there's more to it than that.
Ketones can lead to a serious condition called ketoacidosis. Is that correct?
Correct. Yeah.
All right. Have you ever gone high and your body was telling you that your blood sugar is high?
Yeah. I mean, every diabetic has had high blood sugar. Yes.
And your pump would alarm you if your blood sugar was high.
It will now. Yeah.
Okay.
I haven't always had this pump or a CGM.
When you go low, your reaction is to take simple carbs.
Actually, my current reaction would be to use the what is it called? It's a nasal spray that brings the blood sugar up. But yeah, or simple carbs or anything really.
And the fear is that if you didn't have simple carbs or take the nasal spray, that you might pass out, be unable to awaken.
Right.
All right. And the concern with the high blood sugar, among all the other problems with high blood sugar, is you could develop ketoacidosis.
That's one concern with having a high blood sugar. Yeah.
And the instant treatment for that is to take insulin.
The instant treatment for that?
Yes, if you have high blood sugar, you will take insulin to reduce your blood sugar. Is that correct?
Yeah, that's correct. Yes, that's correct.
There are times when your pump isn't working properly, or the insulin in your pump is not effective, and you have a pen to take insulin immediately and put it into your skin or your bloodstream.
If my pump was malfunctioning or if there was a recall on my pump or an instance like that, then yeah, I have syringes with 2 different kinds of insulin. I have insulin pens. I have an actual blood sugar machine if my Dexcom goes bad.
And if your blood sugar goes low, do you feel tired?
Do I feel tired?
Yes.
It depends on how low and it depends on when. I typically don't feel tired when my blood sugar is low.
All right. The solution to low blood sugar would not be to go and take a nap, correct?
I mean, I guess how low is the blood sugar?
If you had
I mean, with my pump right now, it will monitor it all night and it will adjust my insulin based on what my blood sugar is at every 5 minutes. It checks the blood sugar and it will adjust it. So if my blood sugar is 65 and I do nothing, it will slowly trend back up. So I guess when you say low blood sugar,
how will your blood sugar slowly trend back up if you don't take any carbs?
because I'm not taking any insulin in.
All right.
So my body's without insulin, meaning it's going to go up.
You also have a glucose pen to give yourself instant carbs, or is the nasal spray the alternative to that?
I'm sorry.
You also have a glucose pen in case you're going low to.
No, we don't do the glucagon pens anymore. It's just the nasal spray.
Okay. All right. So the episode that was testified to at the Ionia Skateland, where your daughter was trying to talk to you and you were not looking in her direction, paying attention to her, that was not a low blood sugar event.
I'm sorry. Are you asking me if that was a low blood sugar event?
Yes, that was.
At Skateland,
Yes.
I was talking to my daughter. I'm not sure why anyone would testify that I wasn't talking to my daughter. We went in for 5 minutes, got her skates. She put her skates on, decided that she didn't want to stay, and we left and got ice cream.
All right. You did not have low blood sugar in that moment.
I would have to look at the date and look back at my pump and see what date it was, if my blood sugar was low or if my blood sugar was high, or if I was able to see that day, or if I had just gotten an eye injection, or what was going on that day. I couldn't tell
Ma'am,
you.
you should have more knowledge of that day since that's been testified to in 2 of the other 4 hearings. Come on.
With my blood sugar. I mean,
There,
that's
there, there,
every
there,
day. I'm
there
in
have
there
been
5
questions and
minutes.
ma'am,
My
there's been questions and cross examinations on what happened in that day. To play ignorant at this point in time does not help you.
I'm not trying to play ignorant. My blood sugar, it checks at every 5 minutes, 24 hours a day. So to say if I'm
And
supposed
again,
to,
that's been a question in these hearings.
I don't think they've ever asked about my blood sugar. The only
Yes,
time
no, it's been asked and testified to as to what was happening on that day, and you were found allegedly asleep in your car. You've
and I
tried to
wasn't.
cross-examine on that, and so you can't play ignorant to the fact that, gee, I don't know what happened that day, which is
I'm
what you're
sorry. He
trying to
asked
do
me
right
if my
now.
blood sugar. He asked me if my blood sugar was low,
Yes, and we're
the
trying to
answer was
find out why you might be unresponsive in a car and not able to take care of your daughter,
right. I
according
wasn't
to other
unresponsive.
testimony.
I wasn't unresponsive in a car, so there would be no reason to be unresponsive in a car.
So your testimony is that the witness was perhaps mistaken and that you were interacting with your daughter.
100%, yes.
Okay. She then testified that you went to take a nap in your vehicle.
She testified that I went and took a nap in my
Yes,
vehicle. Then
that's
she's
why this.
mistaken.
That's why
Yeah,
this.
then she's
That's
mistaken because
exactly why this is a question.
yeah, then she's mistaken because we went in, we got her skates, I paid for them. Vanna stood in there for about 5 minutes and then decided that she didn't know how to skate, so she didn't want to do it. I said we can go get ice cream instead, and we left, got in the car, went and got ice cream at Cook's. Or I'm sorry, not Cook's, Moville.
All right. She also testified that you took a nap for an hour. Was she mistaken about that?
She was obviously mistaken because we weren't even there for an hour.
All right.
By
Now,
the way, to clarify the record at this point, Mr. Chadwick, that was on cross-examination. That she denied that and was not there for an hour. I'm just trying to clarify that situation because I've got really examination and cross-examination that goes diametrically opposed, and I'm trying to figure it out. That's why I went where I went. So forgive me for intervening, but Mr. Chadwick, please continue with your cross.
all right. June 24, 2022, you were found in your living room by Savannah.
Incorrect.
Was the date correct? Incorrect? What is incorrect about that?
Being found by Savannah, that's incorrect.
Do you recall the events of that day?
I do vaguely. And Matt Preston was here. He was assisting me. Vanna got dropped off by Tyler shortly before I went to the hospital.
You shush. And you were taken to the hospital. Were you conscious when you were taken to the hospital?
I was.
Did you ride in a vehicle?
I rode in an ambulance.
All right. Do you recall being driven home from the hospital by Brittany Bound?
I don't recall that.
All right. Do you recall admitting to Brittany Bound that you had used methamphetamine?
No, I don't.
Do you recall that your mother and sisters were worried about your methamphetamine use?
No, they weren't, as my mom just testified last time that they did a drug screen and it was negative. So
that's not the question. The question is, were you aware that your mom and sisters were concerned about methamphetamine use?
no.
Were you conscious in the hospital?
In and out of consciousness, but mostly unconscious.
Would you describe your condition as being related to your diabetes?
It was 100% related to my diabetes. My blood sugar was over 1,000. When I got there, I was in the ICU. I had a central line in my neck. I had a catheter. I ended up with swelling in my brain. I had kidney damage from it. It was ketoacidosis that I've never had.
You recall your pump alarming you that you had high blood sugar that day?
My pump there was actually a recall on the kind of pump that I have because of issues like this, where the sensor wouldn't notify, wouldn't correspond with the pump to make those alarms like it was supposed to.
Your
Mr.
boyfriend,
Chadwick, I know we've had some testimony prior to this, but we don't have any medical records from that event. And if you do, did it show that her blood sugar level was over 1,000?
I don't have any records to that.
Okay, I just wanted to know because I know none have been entered. We've testified on this. This is like the third or fourth time we've testified to this event, but that's the first time I've heard of the blood sugar level. So I was wondering if you had any knowledge.
Right.
Okay, please
Aside
proceed.
from-
I apologize for interrupting, but I'm like, a blood sugar level over 1,000 is shocking.
Yeah.
Your boyfriend, Matthew Preston, refused to take a drug test.
I don't recall. I don't know. I don't know.
Are you aware of any time since June 24, 2022, that Matthew Preston has used drugs, illegal drugs like methamphetamine?
No.
Are you aware of any time since June 24, 2022, that Matthew Preston has been tested for illegal drugs such as methamphetamine?
I have no idea. I don't know.
You did not allow CPS investigators to obtain your hospital records?
I provided them with exactly what they asked for. I gave them my drug screen. I gave them a note from my primary care doctor. I gave them the discharge paperwork from the hospital. I gave them everything. The only thing that I wasn't going to do with advice from an attorney was to sign a blanket statement saying they have access to all of my medical records. But I gave them what they needed and what they asked for.
CPS did an investigation.
Yeah, they did.
And what were the results of the investigation, if you recall?
I don't know what term they use, but not substantiated.
And when did you learn of the results of that investigation?
As soon as it was done.
That process took weeks.
It took a long time. Yeah, it took a long time. But the whole time she was never removed from my care at all.
Okay, just question of timing. It took several weeks.
Sure. Yeah.
It's investigation. All right. Kara Griffin is the evaluator from the Kent County Front of the Court who prepared the investigation for the Front of the Court. And on page 5 of 14 of that investigation, Ms. Griffin wrote, quote, during the CPS investigation, Holly refused to sign a release for the CPS investigator to review her hospital records, end quote. Question, during the 2 weeks that it took, the few weeks that it took to get the CPS investigation, you never talked to an attorney to see whether or not you should continue to refuse to sign the release?
I did, and that's what I just said, that they told me to provide them with the medical records that they're asking for, which I did, but not to sign the blanket statement saying that they have access to all of my medical history and medical records. I provided CPS with exactly what they asked for when they asked for it. I did a drug test. She came to my house. They did a whole searched my whole house. I mean, I gave them every single thing they asked for when they asked for it.
You wanted to talk to an attorney first?
I'm sorry?
You wanted to talk to an attorney before signing the release?
I was already talking to an attorney because Tyler had gone and gotten a ex parte order to keep
Question.
Savannah, and he wouldn't return her back at all. So I was already back and forth trying to figure it out.
We've been told that you refused to sign the release because your testimony is you wanted to talk to an attorney.
No, my testimony is that I had already talked with an attorney who said not to sign anything releasing medical records because it'll be a blanket statement, like a blank, every single medical record from whenever. He said to provide them with what they're asking for, and that's exactly what I did. Something from my primary care, my discharge paperwork, my drug screen. I even did a drug screen when CPS came here.
Ms. Griffin wrote further in that large paragraph on page 5 of 14. Quote, some of the concerns listed were that multiple family members and trusted supports of Holly's alleged that she disclosed methamphetamine use to the hospital staff, and Holly refused to sign a release for the investigator to get her hospital records, end quote. So your family was still concerned, CPS was still concerned, even though you claim you've turned over.
I think because I was taking a diet pill that has amphetamines in it. And I think that's where all this I don't want to say crap, but all this nonsense came from, because I had a positive amphetamine test because I was taking what is it called? Qsimia. I don't take it anymore, but it was positive for that. Not methamphetamine. It was a prescribed diet pill.
Is that the reason you did not want to turn over your medical records? Because you knew you would test positive for a diet pill?
I'm sorry?
Is that the reason that you did not want to turn over your medical records? Because you knew that you would test positive for a diet pill?
No, I didn't turn over my whole packet of medical records because that's what they were asking me to do. And I think that had nothing to do with anything. I gave them and I provided them with every single thing that they asked for. I was cooperative. I gave them, they wanted to do a drug test. I let them do a drug test. They wanted my drug screen. I gave them my drug screen. They wanted the discharge paperwork. I gave them the discharge paperwork. I even had my primary care doctor submit something. I mean,
All right. So Ms. Griffin wrote that the CPS investigator highlighted several concerns, and some of the
I guess I don't know if I can object to this because this sounds like if she's
No.
saying that someone
You have
else
to
is
answer,
saying
you have to answer
something.
the question.
Okay.
So Ms. Griffin wrote in her report that the CPS investigator highlighted several concerns despite not finding preponderance of evidence. Some of the concerns listed were that multiple family members and trusted supports of Holly's alleged she disclosed methamphetamine use to the hospital staff. Second one, quote, Holly refused to sign a release for the investigator to get her hospital records, end quote. So CPS was concerned that you didn't sign the release. Your testimony today is that you turned over hospital records.
I did. I actually have the whole CPS report, which includes the records that I gave them.
So their concerns were just misplaced.
Yes, 100%. Same with whatever support system or whatever family members they're talking about. If they're concerned about methamphetamine use, then they've got that mixed up with this diet pill that has amphetamine in it.
All right, I'll object.
And Mr. Chadwick, CPS, through their investigation, I realize she testified to this, but you have the CPS reports. I don't know if I do because I haven't relooked at all the exhibits over 5 hearings, but they did not substantiate.
Correct.
No, I'm asking Mr. Chadwick if he has that
sorry.
information.
I don't have any CPS reports. What I have is
Okay.
they don't say substantiate anymore. They say preponderance or no preponderance, and that was the finding, no preponderance.
Interesting, because I find that they find that there's preponderance to substantiate or no preponderance to not substantiate. They follow through in Kent County, to the best of my knowledge, because that is a huge statement. Because let's face it, their burden of proof is much lower than ours.
Yeah.
Right. All right. Lastly, you testified earlier today that Tyler prevented you from seeing Savannah after this incident in June of 2022.
Correct.
He got an ex parte order.
Yep.
To take away all of your parenting time for the foreseeable future.
Nope. He got an ex parte order that extended his parenting time for 14 days.
All right. And then he was in communication with CPS during that time.
You would have to ask him. I don't know what Tyler was doing during that time.
You did not have parenting time until you filed your own ex parte order, ex parte motion.
Correct. But this was after we went to court after I got out of the hospital. I believe I was in there for about 10 days. I got out, scheduled to see that we scheduled and saw in front of the judge.
Right.
And they revoked the ex parte order.
Stop. I just asked
All right, I was gonna say, yeah, just answer the question, ma'am.
if you got parenting time only after you filed your ex parte motion. Your answer is
Yeah, correct.
okay. And
But during that ex parte motion, ma'am, you were unable to take care of your daughter.
No, I was able to take care of her. CPS had cleared me to take care of her.
I thought you were in the hospital.
So Tyler had an ex parte order that gave him extended parenting time for 14 days. I got out of the hospital before those
Okay.
14 days had
All
come
right.
up.
Then I apologize, Mr. Chadwick. Please proceed. I was
I
trying
guess
to confirm the timeline because it's gone back and forth.
the other ex parte I think he's talking about is when I went and filed one.
Ma'am, there's not a question before you. I was trying to clarify for my notes as I'm writing them to determine if you were incapacitated during that entire time.
No.
Because it's, like I said, it's gone back and forth. So I just wanted to clarify for my notes before we proceed. Mr. Chadwick, you may proceed.
all right, thank you. How long did it take for CPS to clear you when they made their finding of no preponderance? I might have asked you this already.
I
specifically.
guess I don't know the exact time frame because no one ever removed Savannah from my care or anything. So there was no, I guess it took weeks to get the final report, but during that time while they were investigating, there was no restricting her from being with me at all. The court even had said to resume normal parenting time.
Do you have your copy of what's been admitted as Exhibit 1 with all the pink lines on the school attendance records for Savannah?
Yeah, I just looked at it earlier. That's how I started mine.
All right, so I've got what I'll refer to as Exhibit 1.
Okay.
And then your Exhibit 11 that was just admitted today.
Okay.
All right, you want to excuse the white areas of your Exhibit 11 because it was snowy and she walked to school and then her tardies should be excused. Even though it was
I guess I'm not saying that they're excused. What I'm saying is that on here it's marked as an unexcused tardy. So being that it was unexcused, Tyler nor I had any idea that she was even tardy that day.
Well,
tardy means that, you know what I'm saying? That tardy means that she walked into class as the bell was ringing or 2 minutes late. So I'm just indicating that those days are snowy outside. She walked to school.
That's right. You've had plenty of time to explain yourself. I just want to ask
Well,
you.
I was trying to answer the question. Sorry.
I'll ask you a question. You just tell me yes or no, or I don't know. I see that you didn't mark these as orange, even though they're unexcused.
Right. Do you see on the bottom where it says what orange represents?
Yes or no? These are not marked orange.
Correct.
So even though they were not excused by the school, you believe that the referee should not count these because you haven't marked them orange.
I guess we're not on the same page here.
No, obviously you're not. And no, I understand what you've done. And I understand what Mr. Chadwick is trying to say is that you're trying to say these are explainable because of snow. And he's saying, look, they're still unexcused.
Right.
Which is
and
what
I guess,
his chart says they're unexcused. You're
and
trying
they
to say
are
you're trying to say they're excused by you over and above the school saying they're excused.
I guess where I was going with it is they're unexcused. Tyler and where I knew that she was tardy on these days.
Okay.
She wasn't driven to school late.
They were still days on which
They were
you
days
had,
that,
right there.
right.
they were
She was
days in
tardy.
which you still had control of the child, and it was your responsibility to get her to school on time.
I said orange, I meant blue. Okay, blue's Tyler, I get it. But I'm green. The school,
Be glad I'm not colorblind.
yeah, the school calls both parents when there's an unexcused tardy. Is that correct?
Incorrect. They don't call when there's an unexcused tardy.
What?
They call when they're absent. That's what I was getting at, is that these days she walks herself to school unless she was, if I dropped her off, I'd have to go in and excuse it and sign it. These days that are unexcused, I'm not saying that this is 100% the reason, but these days are in the winter when it's snowing. They're unexcused. Tyler nor I knew that she was tardy on these days.
All right, but if we were to color code these according to the school's records, these would all be blue because they're unexcused tardies when you had her the night before. Correct?
I mean, they're unexcused. I mean, that's why on the colors things that are on here, they would be on unexcused. The rest of them are excused. So the
Looks
ones
like,
in white are unexcused. And those are I think those are the only ones that are unexcused.
looks like there's 9 of those from November to February. That's you've described those as wintertime, tardy, unexcused.
That in those there was also 7 snow days during that same stretch.
Did you not understand
The
what
days before and days after.
help me out? I asked you a question. You answered a question I never even asked you. Just listen. There's 9 of those. Is that correct?
Sure, yep.
From November to February.
And
Correct?
she was tardy, less than 5 minutes tardy. Yes,
Who says less than 5 minutes tardy?
the school does.
The school doesn't say it on this document. Correct? School doesn't say it on my exhibit 1.
I guess if that's the case, then how do we know what any of these say then? We're
Well,
just assuming what all these mean. I got it clarified from the school that that's less than 5 minutes tardy.
Okay, well, we can all agree it just says tardy, unexcused.
It doesn't say tardy unexcused at all. It just says T.
The TU says unexcused.
Okay, but it doesn't have that written out. Do you know what I'm saying? Like,
Yeah,
we're gonna
yeah,
argue.
TU stands for tardy, unexcused.
Right.
TE is tardy, excused. It does not give a time limit, and the person that did testify from the school, I will have to relook at his testimony at this point. I'm sorry, I'm not going to
Yeah,
look
he
back at my
couldn't tell
notes
us
right
what they meant, is what he said.
now. But
This is exhibit 1,
correct.
and it's got 3 pages of colored lines. The 4th page has a legend. If you look on yours, I can't really show it to you on the screen, but if you look on the 4th page of your copy of exhibit 1, right at the bottom, it says TU equals tardy, unexcused.
I think I
Right,
just did that.
correct.
Yes.
We
And on the next page, the T stands for tardy. So it's it's pretty clear what the school records say.
right.
So we got those 9 days are tardy, unexcused. That's what it's listed
Correct.
on both exhibits.
We agree. I think we're both agreeing to that.
You're just disagreeing as to what that actually means as to time. They're still all
I guess-
tardy, unexcused on your time.
Well, I'd like to probe the witness if I could.
Certainly you may.
You
Just
don't
trying to
know
put us
if
on
it-
equal footing here.
According to the school documents, you don't know if it was 5 minutes or 35 minutes.
According to the school documents, according to me just going up to the school and getting this printout and them verifying and clarifying that it's less than 5 minutes. Otherwise, it would be an L for late.
That's
Tardy is
all,
different than late.
that's all non-responsive. You can tell me what you were told and it's hearsay. So I'm just asking you, according to the school records,
And I'll note that for the record, I'll take that as an objection to hearsay,
yes.
and I'll grant that.
The records don't say anything about less than 5 minutes. In fact, she could have been more than 5 minutes because you weren't told by the school that she was even tardy. Is that right? That was your testimony.
I guess I don't know because I can only go by what I know from being
I will also
told, so I don't know.
I will also note for the record that none of these school codes indicate an L for late.
The L.
There is no L. All of the qualifications on the reason codes that were submitted on Exhibit 1, none of them has an L for late. So please proceed so that we're on the same footing. The only L is IL, and that stands for illness.
Yeah.
Please proceed, Mr. Chadwick.
All right.
So we have one that says L/VA.
Which
I'm
is
just-
where?
I'm just trying to clarify, 'cause-
What's the date?
4/8/24. I'm just trying to, I mean,
Oh,
I
that's
was
on the
at
that's
the
on your
school
exhibit that I have
all
to
day.
that's on your exhibit that I have to print out to look at because it's so small. All right, I have E excused, H homebound, N not scheduled, T tardy, U unexcused, AE administration unexcused, AT testing, AU absent unexcused, CV college visit, FN funeral, FT field trip, HB homebound, IL illness, IS in school suspension. There we go. MD medical, MS miscellaneous, NC no class today, OS is out of school suspension, PN is no contact, PT parent no reason, RG religious, SB school business, TE tardy excused, TU tardy unexcused, VA vacation, WD withdrawn, WX weather related. There are no other listings on the absence reason codes that were submitted under Exhibit 1, and I believe
Right.
there are no codes under your Exhibit 11, ma'am.
Okay, I'm
So I
just
don't
looking
know.
at going off of what, I mean,
I don't know where LL comes from, and I think if I remember
L,
correctly, the school person tried to testify to that, and he didn't know what it meant.
right.
Now that I'm looking at that, so I'll have to as I will always do, I will rewatch all this testimony before making a decision.
No further questions.
All right. Any further testimony, ma'am?
Yep. So since we're back on this school log, one that says snow days.
It should be listed because they have weather as a excuse. And that would be WX weather related. And we all live in Ionia County, therefore, God help us, weather related is an issue.
Yes. Okay. So, just again, go back to that school log. I'm not saying that that they were unexcused tardies. I'm not like saying they didn't happen, but I am saying that there's reason behind them.
Which is what you've testified to, that you let her walk and it was a weather related incident.
Right. And that's again why it's unexcused, because if had I gotten, you know, I'd walked her in and signed, it would have been excused, opposed to her walking herself in, and us not even knowing that she's tardy. I will say, back since we were talking about this ex parte business, yeah, the ex parte that Tyler had gotten extended his parenting time for 14 days. I got out of the hospital prior to those 14 days. We were seen, we came to the court. I'm not sure what term they used, but they dismissed it. Like got rid of that ex parte. And we were to resume normal parenting time. Even after that, he chose on his own to not resume normal parenting time. Even after CPS said, yep, there's no reason to keep her away from Holly, resume normal parenting time. So this went on from the end of June until August 5th, that I was not allowed, because Tyler wouldn't allow it, to talk to her, to see her. No phone messages, no text messages. Vanna hid in a closet to text me, because he wasn't allowing her any contact with me at all. Every time that it was my parenting time, I would call the public safety and they'd come out and do a civil standby, so that it was all recorded that, yep, I was trying, and nope, Tyler was not allowing it. So it wasn't until, like I said, I think August 4th is when I came and got an ex parte order, because there was nothing Tyler was going to do I mean, he was not going to let me see her, not going to let me talk to her at all. I came there on the 4th. On the 5th, I was able to serve him with the ex parte and bring Vanna home to resume our normal parenting schedule. That whole incident, being away from any parent, I mean, whether away from Tyler or me for that long of a time, is so detrimental to Savannah. I mean, when it's been consistent for 11 years, well, at that time it was, she was 8, 9. It's one way, and then to just be completely without one parent for that long is sad.
Okay.
I object.
Any
Part, the child's conversation with the mom wasn't there.
Well, I was going to ask if, and I'll grant that objection, I'll note it. Any further witnesses, ma'am?
I mean, I don't believe so. No.
Okay. Closing statements, Mr. Chadwick.
it's been a long journey and it's an important one. We look at the motions that were filed, one in 2022, one in 2023. And the parties did have a solution worked out in, I believe it was late 2022, but it wasn't too long after that that the father began seeing the problems that we've discussed and discussed and discussed and taken a lot of testimony on. The problems with the mom zoning out. There was a witness that saw her zoning out. She wasn't listening to her own daughter. And the daughter's statement to the mom, according to the witness, the daughter's
That's hearsay, is that not?
No, we're going closing statements. He's doing this
Okay.
based on testimony that's been presented to the court
Gotcha.
over now 5 days.
The daughter's statement to the witness, I believe, was an excited utterance. She just said she does that all the time. So
Again, that was testified to and not objected to at that time, and I considered it an excited utterance anyway. So yes.
Yes, and I think it's significant because the daughter knows that this behavior happens. The daughter's embarrassed by it. The daughter wants to explain it. She wants to understand it. Then the witness said that the mom went out into the truck and took a nap for an hour. So either it was lack of sleep, could have been a low blood sugar incident, could have been a high blood sugar incident. We don't know. Could have been drugs. If she was on methamphetamine at the time, that might explain the behavior. But it was a concern to the daughter, and it was not new to the daughter. It was behavior that she had seen over and over and over and was able to express that in the moment to the witness, who was also concerned about seeing the mom in that situation. You look at the June 2022 situation where the mom was found. The evidence is that she was found by the daughter, passed out, naked in the living room. Again, you could say that was low blood sugar or high blood sugar. Does not sound consistent with high blood sugar, but we don't have any medical evidence one way or the other, so we're stuck with the testimony of the mom who says it was high blood sugar. However, when you pass out, you don't get a chance to take your clothes off. You would already have had your clothes off before you passed out. And where was she when she was found passed out? She was in the living room. That is not a place where you would normally be naked around your house. Bathroom, bedroom, perhaps. Living room? No, there's something strange going on in that situation. And the fact that she was found by the daughter, and the daughter worriedly called the grandma, Ms. Wright's mom, and then the ambulance came and took her to the hospital. These are huge concerns. And again, Mr. Coleman couldn't ignore that. He had to file a motion. He had to make sure that she was in a safe house, that Vanna was in a safe house. And he can't control what happens when Vanna goes to mom's house. That is mom's responsibility. You have events like these, you can say that it's because of high blood pressure or high blood sugar, low blood sugar, but it does seem inconsistent with that explanation. It does seem more consistent with someone who is on drugs. Add to that, there are people in the home who have criminal records, people in the home who at some point, we noticed that they did not have a driver license. Mom can't remember when her boyfriend got his driver license. That was her testimony today. I don't know when he got his driver license. Has he driven your daughter around? Sometimes. I think that the mom would know whether her daughter's being driven around by a licensed driver and would prevent that illegal activity from happening, and at least would want to know that. But this mom doesn't know that, doesn't know when he got his license, and she just tells the court that he has a license now, even though there's evidence that for much of the time that we've been studying the last 2 years, he has not had a license. You look at the house, and I don't excuse any of it. The basic responsibility of every parent is to provide a home for their child. This mom could not do that, chose not to do that, couldn't pay the water bill, couldn't make a house payment. She gets behind on the house payment. She gets behind on the water bill. Now she's going to hit up the family to help her get her water turned back on. And that cost her another $75 every time it happened. Her testimony was she remembered some, she didn't remember others. But it seemed pretty consistent from the bill. Again, we didn't admit that into evidence, but it sure seemed pretty consistent that every time there's a water bill due, the water gets shut off because she's not paying the bill. And she's got other adults living with her. She's not financially responsible for them. She's responsible to meet the basic needs of her daughter. And she wasn't doing that. And these adults that she was carrying were not helping her with that either. So, and her testimony was her mom didn't help her pay the water bill. She was very adamant that mom did not help me pay the water bill. I don't know why you'd want to deny that, but if it's true that mom didn't help pay the water bill, then what's wrong with mom? In other words, grandma, what's her first name? Nancy. What kind of woman would say, no, I can't let you turn your water on when you know that your granddaughter's going to be there half the time? And what grandma says to the I didn't hear her say the normal things like you have to learn to pull yourself up by your bootstraps. You have to learn personal responsibility. It was no, she doesn't ask me for money. I gave her $20. I've never given her more than $20. Okay, if we want to take you at your word, Ms. Wright or Nancy Wright, yeah, if we want to take you at your word, Ms. Wright, we can. But why, if she's working and her husband's working, Mr. Wright, how come they were not helping Holly Wright financially so that the water was turned on, so they didn't have to take charity and live in a hotel for perhaps up to a week at a time? The testimony was contradicted by Tyler. He said it was a week at the longest period of time. Ms. Wright denied that. The fact is, he goes to pick her up, and she's not at Holly's house. She's at a hotel because heat's off, water's off, no electricity in the house. It's wintertime. This is not a responsible parent taking care of the basic needs that any parent would have to do to take care of a daughter. What are we going to do if we leave things, as Miss Wright would like us to do, leave things the way they are? You think a year from now any of this is going to change, or are we going to have 4 more unpaid water bills and water shutoffs where we've got to pay money to get the water turned back on? Are we going to have more hotel stays? Is she going to be late for school more? Is she going to be unable to get any help? I understand Ms. Wright has a job and she's had 1 paycheck so far, but we have a 2-year track record where she has not been able to financially provide for her daughter. And it's one of the factors. It's a very important factor, factor C. And there is some child support that can be used, as the Court of Appeals has said, there's child support that can be used to remedy some of that. But when you've got a mom with no income for 2 years, no support from her boyfriend for 2 years, minimal support from her family for 2 years, what makes us think that year 3 or 4 or 5 is going to get any better? It's time for a change if we're just simply looking at math, objective facts, and Savannah's best interests. Last thing is the missing school. I mean, this should be a fairly easy call for any trier of fact. You've got so many tardies and absences where the child is not getting to school when she's with mom. She is getting to school when she was with dad. There's testimony that he gets her ready for school in plenty of time. They go to Big B Coffee on the way. They get a special drink. Yes, it's a high carb, high caffeine drink for the child and the dad, and that's what they enjoy. And then she gets to school in plenty of time. We do not have the same level of yellow that we do with pink with this document. It's simply not. It's night and day. So how are we doing this child any favors by saying we'll just continue doing this for another year, for another 2 years, another 3 years? Isn't it a simple, easy call just to say when she's with dad the night before, she gets to school on time, when she's with mom the night before, she gets to school late often, or doesn't even make it to school? And there's a lot of absences that are unexcused. There's a lot of tardies that are unexcused. Whether a parent is told that by the school or not, it's still the parent's responsibility to get your child to school on time. Every parent knows when the bell rings, when all the other kids are already in class, and your child's the last one there, she's late, she's missed something, she doesn't know what, whether it's 5 minutes or 15 minutes. If it was only 5 minutes, it would be a very easy fix. You just get her going to school 5-10 minutes earlier and you got no problem, but that didn't happen. So we're here making excuses saying it's not such a bad problem when you've got so many of these. I mean, we're looking at dozens of absences and tardies throughout a school year when mom has her the night before. It makes sense to say that mom should have the parenting time every other weekend and dad should have the parenting time during the week. It makes sense to say, as the front of the court investigator recommended, that the mom does not have overnights on the weekends, that she has non-overnight weekend parenting time on alternating weekends. Because what are we trying to do? We're trying to keep the child safe from the criminal element in the mom's home, safe from the lack of resources in the mom's home. And someday, perhaps, she'll get her Social Security disability. But right now, she's not getting done the basic things that she needs. So what we would ask is that the court adopt the recommendation of the friend of the court investigator. Thank you.
Thank you, Mr. Chadwick. Ma'am, your closing statement? Hello?
So after hearing everything that that they've had to say and witnesses that have no merit accuse and allege that they've seen me sleeping in my car, there's nothing that shows that. Savannah, yeah, she is used to me looking around the building because my eyes are bad when I am searching for something. Or when I am moving my eyes around, it's to move the floaters from one side to the other so I can see what's going on. It's unfortunate that whoever this witness is that says that I looked like I needed, like she was concerned, instead of asking me if there was anything she could do, instead she just walks away and then testifies that I was passed out in my car, which it sounds like, Tyler's saying that that's a drug thing. I don't know enough about either any types of drugs to say whether or not that would be. I can say that that never even happened. As far as her being with one of us rather than the other for school, it sounds like they're trying to say that it's better to miss a full day of school than it is to walk in a minute or two late. I think that's ridiculous to say that, to justify the absences that have happened on Tyler's care just because it's a half day and he doesn't want to take her, or he's got work to do, so she's just going to stay at home. If that's really what they're saying, that missing a whole day of school, I think there was, 9 of them on this past year and when she was with Tyler. And the only ones with me were when she was sick. I mean, you can see that right there. I mean, clearly her school work didn't suffer from any of that. I mean, her report card states that if she was truant, they would have sent a letter saying that she was truant. She was excessively late. We would have heard from the school saying that she was excessively late. As far as being able to provide for my daughter, yes, I had, with this disability, waiting on this, it's tough. But luckily, I had a 403B. I had a retirement fund that I could pop in and pull from. So I didn't go without money. I didn't go without a home. I didn't go without the necessities that we needed to live. I was able to do it. I was able to get through, and I have been able to, and I still am able to. I've been able to do that throughout this whole thing. If I needed help, luckily my family was there to help. If I wasn't able to do it on my own, which a lot of times I am able to do that. As far as the recommendation from the friend of the court, after reading through that, the recommendation was based on the evidence that I wasn't able to submit. I, with my eyes being bad, need help navigating through a computer. I didn't have the resources. Wasn't able to get that to them in the allotted time. So here we are. If it will even say in there, if there's because of Tyler saying I have no home and I'm homeless and my house was taken away and auctioned off, that is why they didn't want to do overnights at my house, presuming that I didn't have a home. With any allegations of drug use, that hurts so bad because I have worked in healthcare my whole life where they do random drug tests, all these different things. And to have people randomly in the community, because of the things that Tyler's saying, even when they're not true, I have to walk around with a negative drug test paper in my pocket so that I can throw it out there and show people. If anyone thinks that changing the way that this has the parenting time and the custody to Tyler having her all week and me just having every other weekend, if that is clearly not in her best interest ever. I would never ask that. I would never even ask the court to do that in my favor either, because kids need both parents like she has had. In Michigan, in order to even change, in order to change the custody agreement, there has to be proof that there's been a change in custodial environment. And Tyler's failed to do that. He's not been able to provide any evidence showing there's been a change in that custodial environment. I think that is why every time he's filed for it in over the past 3 years, it's been thrown out of court because there's no proof. There's nothing to show that. Sorry, I'm just checking to make sure I've got my.
It's okay. At least you're moving. I can tell you're not frozen.
The only change of circumstance that I think makes sense in this case is the fact that Vanna's gotten older. And here at my house and under my care, I have accommodated that. When she was a baby, she had a crib. She had bottles. She, had tummy time. When she was a toddler, she moved into a toddler bed, had a sippy cup. When she was in elementary school, as she got older, she has a twin size bed, and she's got more independence. At Tyler's house, he continues to treat her like a baby. She has bottles that she drinks there for fun. She still sleeps in bed with daddy. He ties her shoe for her. There's no adapting to her growing up. And that's sad. So what's in her best interest would be to continue the way that we have been going, where it's almost 50-50 on parenting time. We have joint legal custody. And I have the sole physical, since it seems to have worked for the last 11 years, and Tyler can't prove that there has been a change in custodial environment at all. I think that's
Okay. All righty, ladies and gentlemen, I believe my clerk has a date for you. Buried it. September 10th at 11 a.m. If everyone's available, I will try and make sure this opinion is done at that point. I will be rewatching all 5 days of hearing.
We need to have a Zoom hearing to listen to your opinion.
Well, if you want to hear what I say, I mean, most people don't want to hear what I have to say, but I think in this case you might want to. So yeah, it'll be a Zoom. I won't make you come into court. There's no reason to do it in person. I actually one time had only the 2 attorneys show up for my opinion. The clients didn't want to be there. That was a weird one. 18 years. That's only happened once. But I'm willing to accommodate. But 11 o'clock by Zoom. And again, I'll issue the opinion. Whether you want to be here or not, that's your choice.
Okay. All right. I'll have to send an associate.
Well, no, we'll find another time. No, Mr. Chadwick, no. That's why I offer the time.
Okay.
I'm not saying we're trying to get it done before I go on vacation the following week.
Yeah, well, we have another date. I'm on vacation after.
No, hey, and again, that's why I also ask the parties. This is a 2-way discussion, not a 1-way one.
Okay.
I want to make, if somebody's got something big at work on that day, God, no. Everybody wants this done, but I've got to rewatch 5 days of hearing while I'm doing 30 to 70 other hearings in the middle. So, oh, great. Okay. He's gone 9. Yeah. Okay.
Nobody takes vacations in September, but my family, we homeschool our kids. We always love that time. We got the whole lake to ourselves.
I was going to say that is actually the best time to go.
We love it. Yeah.
Yeah.
From Labor Day till the 13th.
Okay. So, okay. Rebecca, it's going to have to be the end of September then. Because I can't watch all these hearings, go on vacation and come back and give an opinion. My mind is not that sharp. I have the memory of a gnat and the attention span of a squirrel. So what I try to do is watch the 5 days of hearing within at least a week and a half of when I issue the opinion. I want it fresh. I want it all together. Because as we've discussed in this hearing, we've gone back and forth. There are testimony that I have to rewatch, and I have to actually put Exhibit 1 and Exhibit 11 next to each other. So, I don't do this off the cuff. I did it off the cuff about 5 weeks ago, and now I've got to reissue the opinion because I thought about it within the next 2 days of that issuing that opinion, because it was a short hearing. It was like 2.5 hours. And I thought, I got this. It's simple. I issued my opinion, and I didn't sleep that night. And I basically went, I got that wrong on this issue. This one issue, I got wrong. So I'm issuing a reconsideration. So I don't want to do that. I want to rewatch the hearing. That was a lesson relearned.
John,
I've always said,
if you want me to tell you what you got wrong, I'll be happy to help you with that.
My wife and my children do that enough, thanks.
Okay.
I got that covered.
Okay.
Okay. So I just want to try and get it right. And all of you have said things, all of you have argued back and forth, and I want to make sure I hear all the arguments and relook at all the exhibits before I make a decision. So Ms. LeVay, October 3rd at 3:00. While I was jabbering, she gave me the number.
Yes, that works for me.
And thank God I'll have a haircut by then. My wife wants me to go as Hercules or Zeus for the Mickey's Not So Scary Halloween party, so I'm letting my hair grow out so it fits the costume. It's driving me nuts.
Glad we're done. We accomplished a lot being closed at the close of proofs. We're all done with proofs.
I think we're all done, and I will see you on October 3rd. The dreams have been just you guys the past 2 nights. I have rewatched all of the testimony, and as always, well, not as always, but every once in a while you get hit with one of those hard cases that need a decision. So the court will attempt to do so and justify it with case law and statute. We are here in the matter of Coleman versus Wright. The court has had over 5 days of hearings. Not full days, but 5 hearing events. Approximately, I believe, 14 hours worth of testimony. The court has heard from 11 witnesses, including both of the parties. We have heard from Mr. Mercer, who is the truancy officer involved in this matter, working with both parties and the young child. Ms. Jansen, Ms. McGillis, former coworker and friends of the plaintiff, Ms. Oakley, who is a friend of the plaintiff, Ms. Wright, as well as Mr. Coleman, Mr. Gordon Taylor, Heather Hoppaw, Nancy Wright, and Ted Wright. In a review of all of the testimony, before a court may do anything, the court must determine if there is a custodial environment. The court has also met with the young child. It was not very helpful. I think the front of the court found that same thing. The court has reviewed all 12 exhibits. Those exhibits include the school absence list was Exhibit 1, and Exhibit 11 was the updated absence list that included March and April of that same year. The first Exhibit 1 only went to the end of February. The court has reviewed the Exhibit 2, the iChat on one of the parties' involvements, the FOC recommendation, pictures, the Michigan Department of Corrections, issues concerning Ms. Preston, Ionia Animal Shelter involving Karma, the dog that bit the child involved in this matter, the pictures of the dog bite and past dog bite incidents, as well as a couple of extraneous photos that were not very helpful. In any event, the custodial environment in this matter is with both parties, joint legal and joint physical. Both parties have been involved with this child. Both parties have made decisions. The court has concerns about both parties in this matter. The anger and demeaning nature that Mr. Tyler has toward Miss Wright was more than palpable, and I have grave concerns about how he interacts with her. The greatest concern here is the child's schooling. There has been testimony that this child is not doing that well in school, and the mother seems to be obtuse as to her lack of involvement. In the 2022-2023 school year, which is where this all began, and this is what started this issue, was 2022-2023. The dog bite to the child's face happened in December of 2022. The child missed 67 problematic days on mother's parenting time. I believe she had only 14 on the father's time during that school year. The secondary school year, when everyone knew things were going on, the mother still had over 23, almost 28 in review of the updated lists of tardies and absences. This does not help the child at all whatsoever. And mom seems to try and give some concern, but doesn't seem to alleviate the issue. So this court is basing a lot of its opinion on helping this child in her school situation. I believe from testimony that this child has some medical issues that both parties seem to be oblivious to. Hot chocolate drinks from Big B's, great. Every once in a while as a treat, but 500 calories with 66 grams of sugar to a child who's pre-diabetic is a problem. And the mother, don't shake your head. You ain't any better. Testimony indicated that you also give this child sugar drinks. No, that was uncontroverted testimony, ma'am. There was testimony that you also don't feed her all that well. You also seem to have a problem, like I said, getting her to school. Now, the environment is predominantly with the mother now, but again, the court finds that this child looks to both of these parties, so the custodial environment is with both parents. So the court won't be making adjustments to account for that. But I am going to be heavy on how much time both of you spend with this child. I'm not removing this child from either one of you. I am going to adjust overnights to make sure the child makes it to school. Before the court can make any type of decision, the court must review the best interest factors as to the love, affection, and other emotional ties existing between the parties involved in the child. You both love this kid, and it's obvious this kid loves both of you. I don't ask for parents to be perfect. You are both flawed. But we don't get to choose our parents, and she seems to enjoy the fact of whose parents she has. And that entails both of you, regardless of your lack of trust with each other. So that preference is given to both parties in this factor. Capacity and disposition of the parties involved to give the child love, affection, and guidance, and to continue the education and raising of the child. Folks, this is where mom fails. The preference is given to the father under this. This goes to the past history. There was a truancy letter issued according to the truant officer. It didn't meet the viability of a truancy case for the second year, 2023, 2024. That's because tardies don't count. Had they have counted, there would have been a truancy issue. Again, if the child was doing very well in school with all ones, great. The child isn't. The child has reading problems. The child has problems with math. Being late and tardy does not assist this child in any way, shape, or form. So that factor does weigh on behalf of the father. As to factor C, the capacity and disposition of parties involved to provide the child with food, clothing, and medical care, or other remedial care recognized and permitted under the laws of this state, I believe that factor actually goes to both parties. The father has some concerns about the mother's income. Mom is applying and has had problems with a disability. She has been a diabetic since she was in elementary school from testimony and court records. She has failing eyesight and is now legally blind. She has applied for disability. Legal aid is assisting her with that disability claim. The court does not adjust or concern itself with someone's income as part of changing custody. That's what child support is for, and that's how it's adjusted. In this case, there are some other factors that may readjust that. However, the concern that father has is misplaced. It's the mother's home environment and her ability to care for this child and love this child. And the same with yours, Mr. Tyler. Both of you love this child and can care for this child. There are some concerns with the sleeping arrangements at the father's house. The only thing the court will order, Mr. Chadwick, is the fact that I do want her to have a separate bed maintained and cleaned and a separate sleeping area. Even if that is divided by a curtain, it's still a separate area that she may call her own. So his stuff is not to be on her bed, so that it is available to her at any and all times. Again, factor C is going to be weighed on behalf of both parties. Factor D, the length of time the child has lived in a stable, satisfactory environment and is desirable of maintaining that continuity. The mother bought her house in 2021 or 2022, and that's somewhere back when she was still working full-time and had the availability to do so. Luckily, the foresight was there to buy insurance, and the housing was funded by HUD. So the Housing and Human and Urban Development faction of the state and federal government. Because of that, certain insurances were put into play. I am not going to blame the mother for not having enough money during a time period in which she is working on disability for having problems with payment of bills. Luckily, she had, again, the foresight to issue insurance on that behalf. Those other extra loans, as noted, I had no evidence that those weren't other than standard HUD requirements that just paid the mortgage. It didn't give her money. It maintained her household. Now, as to the household, it's as stable as it's going to be, but I'm afraid Mr. Tyler's household is much more stable. He's been there for 7 years. Ma'am, your household has this problem. You choose very poor quality people to be within it. You've chose people that have felonious backgrounds. You've chosen to expose your children to this. One of those parties, and I realize some of it was your heart that brought in one of those parties who you were going to take care of their child, but Child Protective Services was involved and you had her in the house, and Protective Services had problems with her. Yet you brought her into the house and brought her and exposed her to your child, at which time her dog bit your child in the face. Now, Child Protective Services have been involved with both of you. Again, the court has concerns about both of you. However, you're both her parents. As to you, ma'am, one of your former boyfriends broke into the house. You had to call the father of your child to come and help you with that. Good job, and I'm glad for Mr. Coleman to go and help you. But at the same time, it does evidence the quality of the people you have around this child. I'm willing to give one or a couple of, I made some bad mistakes, but it seems like almost everybody you have around this child is a problem. and has poor backgrounds and is not a good person to have around your daughter. So no, you've been making some very poor mistakes. The length of the time the child has lived in a stable, satisfactory household does not go with you. That will go with the father. As to the permanence as a family unit of the existing or proposed home, for very similar reasons, that factor is going to go with the father. Moral fitness of the parties involved. There's been some concerns of drug use and testimony from actually a couple of the witnesses, including your own witnesses, ma'am, that there were concerns about methamphetamine use. Sir, I don't have much faith in your ability to determine drug usage. For what you described, if you had any real training about the time that she was on the porch, yelled at your mother, was crying, you would have referred to that as a labile affect if you had any training. And that does and is indicative of what you have accused, which is methamphetamine use. Whether it was or not has not been proven to the court. But I will say that the event as described by the witnesses that were involved indicate a labile affect which could have been caused by some substance abuse. However, methamphetamines does not cause the symptomology that has otherwise been complained of about her being tired, lethargic, in her car, asleep. Methamphetamine would be the exact opposite. So that I can't give credibility to. What I will give credibility to is her diabetes and hypoglycemia. And I realized that there was an event where she was found on her front room, I believe, floor and had hospitalization. There's no evidence that that was anything, but according to the testimony and some of the records that were brought out, there was concerns that methamphetamine were being used, but the methamphetamine tests came back negative. So they were not being used at that time. So, but as to the moral fitness involved, I don't find that there's really enough testimony to say either one of you are morally unfit. The choices of the household people and exposure has been taken care of in the previous factor. I'm not going to weigh that on both factors. The mental and physical health of the parties involved, I will note that Miss Wright has severe diabetes and is losing her eyesight because of that. She had a 15-year career in working in hospitals and had to end because of this. So she is fighting an illness that has a prognosis that is going to considerably and continually be worse. So I will reserve on issues of child support because of that, but there are issues that do affect this. Mr. Coleman, you seem pretty healthy and you're doing well. You seem to have a good business and good friends to help you run that business. I congratulate you on that. Please continue. As to the homeschooling community record of the child, again, that goes in favor of the father. Ma'am, it's the main issue the court has to deal with. This child missed so much school, was tardy and late to school. There were several occasions, by the way, at least a half a dozen occasions, according to the paperwork, that weren't really mentioned, but the court, when reviewing it, noted, at least when things happened with the father, there was contact with the school. There were over a half a dozen occasions that it was noted, parent, no contact on your occasions. That means you didn't even call. The school had no idea where the kid was. That's according to the truancy testimony and the documents that both you and he entered as Exhibits 1 and 11. The court has considered the child's preference, and again, it was not helpful. The willingness and ability of each of the parties to facilitate, while there's been some friction there, I think the two of you have done pretty well on working on extra time and extra dates. I hope that will continue for the benefit of your daughter. I think that needs to continue. Mr. Coleman, if you could put away your animosity. Ms. Wright, if you could be a little bit more consistent, it would all be helpful. As to domestic violence, the court read the front of the court report, but there was no testimony that brought that into play. That was before the court during any of these, so the court will not weigh that factor. At this point in time, I'm going to say that the court is going to grant what has been the established custodial environment, which is joint legal and joint physical custody, to both parties. Physical custody is just a word. What matters is the parenting time. The parenting time will be such, and it will start on the first week of November, because I need the child to be stabilized. I don't spring things on children when I'm changing something. So at this point in time, that will be, I believe, November 1st is a Friday. So it should begin with whoever's weekend is that weekend. The parties will each get Friday after school till Monday at school. I'm giving mother a chance to show that she can still be involved with the school. So she will get every other weekend, Friday after school to Monday morning. She will make sure the child's at school. If not, the child can then be, if there is no school, she can drop the child off after you're done with work, Mr. Coleman, on that Monday. She may have the child on that Monday. Okay? So if there is school, she drops them off at school. Otherwise, it's at, I don't know what you work till, so 4 or 5 o'clock. That way you can work without having to worry about daycare.
Are you talking about me?
Yeah.
I got a 5, but she can come to my office.
Yeah, I know. I'm trying to avoid that.
Oh, okay.
I'm trying to give you a chance to do your job.
Oh, I appreciate that. Thank you.
All right. And mom is going to be available because of her disability that she can watch the child. Okay. So if there is no school, then her parenting time will end at 5. You can pick the child up after you're done with work, sir. I'm going to have most of the transport done by you because of her disability. I think it's safer for you to do it. I think then you'll have the availability and ability to do this. I think you're quite capable of that. She will also have Tuesdays and every Tuesday and Thursday after school until 8. When the child turns 12, that will go to 9 o'clock. The rest of the time is yours. She will have every other week in the summer, starting with the very first full week of summer. That will always be hers, and every other week throughout the summer. Ma'am, I'm doing this to adjust for the fact that try and get this kid to school, and I'm giving you some benefit of the doubt to give you Monday morning. I will note, Mr. Chadwick, that you may put in this judgment. If she misses more than 2 days of those Mondays, or if she is late, I will reconsider whether the mother gets the Sunday overnights. So I'm giving you a chance here.
Can I say one thing real quick?
What?
Our previous was actually me having full physical, and
I know.
Doing.
And
I thought I just
no, the word, like I was trying to explain, the wording was not the end all to be all. You guys were exercising almost equal time. Okay, because you were exercising equal time, the word custody was just a word.
Right.
Over time, it became joint, and I'm leaving it as joint legal and joint physical. Okay, Mr. Coleman had some interesting comments about the doctor, which I would be concerned about too if the doctor didn't remember something about my child. I'd worry about their future. So you both have joint legal custody, so you both have input to that and the schools. All right. But mom, you're getting every other weekend. You're also getting Tuesday and Thursday evenings. As to the child's activities, if you guys can't agree, that's what legal custody is about. And we may have to work on an argument about that if the child wants to engage in something and one parent is saying no and the other parent's talking to the kid saying the kid wants to. And we'll discuss that, whether it's appropriate or not. There are times the court will engage. There are times the court will not. It depends on the circumstances because we prefer to stay out of the minutia of your lives. I don't want to micromanage your daughter's life. Okay. That should give the mother approximately 108 overnights, if my math is correct. Mr. Chadwick, I will send you a copy of the holiday times that are ordered by the court. I will also note that those holiday times include half of the Christmas break, every other spring break, but the summers will be divided. Like I said, the first full week will go to mom, and it'll be every other week throughout the entire summer. And that will include your weekend. So it would be Friday at 3 or 5. Okay. If in other words, if that first full week starts with your weekend, it's the Monday through Friday attached to your weekend. So though every other weekend is what anchors everything. Okay. If it's not your weekend, then it should begin Sunday night and go to the following Friday. That way everybody gets the full 7 days. Okay. Ma'am, I realize this is not something that you wanted. And sir, this is not what the front of the court recommended because the front of the court recommended you to get sole legal and sole physical custody and mom was not to have much overnights at all. I'm doing this because your child deserves both of you in her life. What I'm taking away is the nighttime routine so that dad can handle this and get this kid to school every day. During the summer, that's what's happening. You guys will have equal time when the child's awake and not in school.
Not to interrupt, but is there an opportunity to bring up this current school year?
Too late. We're done. I've taken 5 days of testimony. I'm making my ruling, and that's where we're at.
And
again,
what about what? Doesn't have the bed situation settled?
Testimony was that he had a bed for her and that it had its own separate spot that was covered by a curtain. I'm assuming that is accurate and true.
That was his bathroom. His bathroom doesn't have a door.
Well, she needs her own space and her own bed. That's the only thing that the court requires. Okay. And since she's going to be spending most overnights there, she deserves that space, Mr. Coleman. You need to make that happen because she's going to be spending more overnights with you now. Child support is reserved because we don't know what's going to happen until disability is either granted or not granted. Child support at this time, however, will be set at 0.
Is there an opportunity to appeal or go higher?
You may appeal this, ma'am. There's a 21-day appeal period once the order is entered.
Okay.
Just be careful because that puts everything back on the table, including the front of the court report, which granted him sole legal and sole physical custody.
Okay.
Because there were other issues here. While I've stated them and held them against you, I am not holding it against the time with your child because I believe that the child has an important role in this. And I think it would actually not be in the best interest of the child to take the child away from you with as much time as the friend of the court was trying to do. I'm trying to do this to balance the best interest of this child's education, health, and well-being, and the time that the child believes is important to be with both of you. So Mr. Coleman will have more of the control of the school year, and then you'll share most of the rest of the time equally.
Okay.
I believe that covers everything. Mr. Chadwick, I know that I can't do much with child support because nobody gave me any paychecks. I know that she's applied for disability. I know she had a background, but I don't even know what Mr. Coleman earns. So there's nothing I can do. The best I can do is say under these facts, it would be 0, because I don't believe that it would be appropriate to have Ms. Wright pay child support at this point, but it would also be inappropriate to have Mr. Coleman pay, because I think with him having an income and hers at 0, even with her having only 108, he might pay a little bit, he might not. It would depend. And we'll see how the disability, God, I couldn't think of the word, vets out. I wish you well with that, Ms. Wright. Legal aid is still assisting you with that, correct?
I don't have any legal aid or anything. It's just me.
I thought that, well, the testimony was during this trial, during these hearings, that you had a legal aid attorney that was
that was
assisting
supposed to be helping me, and then she never showed up.
With-
It
with
turned out
dis-
that that
with dis-
legal aid-
with
It's
the
this-
disability.
It's with all of it. It was the same attorney that turned out
Okay.
being there.
Okay, well, I suggest you see
Secretary.
if you can find an attorney that will assist you with disability, because otherwise it generally gets denied at least once, and on
Yep.
average it takes 2 years to be accepted as disabled.
Yep.
And from the testimony that I've heard, you should qualify, maybe not
Yeah.
right now, but within the next year or so, I would think that you would qualify. It was nice meeting both of you. It was nice meeting all of your friends and family and have them testify, some of which, and I will say even your witnesses, Mr. Coleman, testified that she's a good mother. All but 2 of them. 2 of the witnesses did not agree with that, but most of the rest of the witnesses did, and said that they've seen, the ones that have seen both of you with this child. And that's what I'm trying to do. I'm trying to keep as much time with both of you as possible. Okay? Good luck, everyone. Any questions, Mr. Chadwick? I'll have my assistant send my holiday schedule to you, and it'll be in Word format. That way you can just cut and paste. You may have to change who starts holidays because nobody testified as to who's the next holiday is. So you may have to check with your
Our
clients.
holiday schedule is a little
That's
crazy,
why
but it
that's
works
why
for
I'm
us.
putting one in. And what this also is to attempt, this child's old enough to walk from your doorstep to Mr. Coleman's car. This is an attempt, like I said, from school on Friday to school on Monday. That's less that you have to interact with each other. And that's what I'm also trying to limit. Okay, because of the interactions that I saw during these hearings. All right, everyone have a good afternoon. Take care of yourselves. Good luck.
With the appeal process,
The appeal process is there will be instructions at the back page. There will be a 21-day appeal period language in accordance with Michigan Court Rule 3.215.
okay, perfect.
Mr. Chadwick will have to put that on the order. Okay?
During the school year,
Yes.
parenting time is every other weekend with alternating weekends with each parent,
Correct.
Friday through Monday.
Correct.
Okay.
Obviously, that's a little bit easier for father on his weekends because it just flows. Because
Yeah.
she's only got the Tuesday and Thursday evenings from after school till 8, and when the child turns 12 till 9.
Friday from after school or Friday from 5 o'clock?
After school.
Okay.
Yours obviously is after school or 5 o'clock. I don't know what you're going to do with those 2 hours. That may be the 2 hours you have to take her to work.
That's fine.
That's your weekend.
And
All right.
then Monday is before school, or what time?
Or until 5 o'clock on Monday if it's her weekend, because she has the availability to watch the child if there's no school, and Mr. Coleman can then work and not have the child running around the office.
All
I'm
right.
trying to limit that as well for the parties.
And as far as our weekday, the overnights during the weekday that she's been with me for most of it, and we're changing that, so I don't have any overnights during the week.
Correct, because you couldn't get the kid to school on the mornings. I'm at least giving you the Sunday night
I
and giving
guess
you the chance for Monday.
we looked at different things then, because the ones that were tardies, I know it's too late again to do the testimony on it again, but the ones that where there was no contact was because she's tardy and walks to school, but that's neither here nor there at this point, I guess.
And again, that was the main concern. And again, you're showing you're being obtuse about the real necessity of this. Have a good